Hi, good morning. My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is October 24th, 2024, and this is case DCI 2024-00013. It's a request to rezone to the IPD zoning district in the Gateway Airport Planning Community off of Three Oaks Parkway. Because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
Yes.
Thank you. I do not see any members of the public here today, so I will dispense with those instructions and we can begin whenever the applicant is ready. Good morning.
Good morning. I am Al Quattrone with Quattrone & Associates, representing our client, Alan Freeman, for this rezoning case. So the name of the project is Pinnacle at Three Oaks Commerce Center. This works. Sharon.
Oh, hold on. It's not. Let me see if I can do it from here.
While we're doing that, I have copies here
Yes.
at the PowerPoint. Okay, so I will accept those as applicant's Exhibit 1, and I did receive a 48-hour letter, which is applicant Exhibit
Can you
A.
try? No? No?
No.
I just tried it
You need
a
a new
minute ago
battery?
and it worked. I don't know what happened to it. Shipping the battery?
I don't know if you got it.
I have batteries here.
Do you?
No. If it, you,
Let me see. Is the thing in there?
There's a cover for the battery. It works.
Yeah.
I'm the one doing it from here. Try to see.
Oh, did you just do that?
Yeah.
Oh, so it wasn't.
Oh,
It was magic.
Okay, all right.
it works. No, it
Okay, we're good. Okay. So the development team is the applicant, Alan Freeman is trustee for the property. With us today is Richard Aiken, attorney from Henderson, Franklin, Starnes and Holt. As mentioned, Al Quattrone. And Ted Treesh is our transportation consultant, but he is not here today. I don't think we really need him either way, but this is a brief outline of our presentation we'll go through today. So, as mentioned, the request is to rezone from agricultural AG2 to mixed-use plan development for office, retail, commercial, and/or industrial uses, as well as up to 200 hotel rooms. We're requesting a maximum of 705,000 square feet of floor area, including a minimum of 30,000 square feet of commercial and a minimum of 30,000 square feet of industrial to meet the mixed-use plan development requirements. We're asking for a maximum building height of 85 feet with the understanding that anything over 35 feet has to maintain the additional setbacks. And we're also requesting minimum open space requirements of 25% for commercial uses and 10% for industrial uses. And that'll be explained a little bit more as part of our deviations of how we got to that.
Hold on one second. So maximum building height is 85 feet because I had 75 shown in the conditions.
The conditions.
2B shows a maximum building height 75 feet.
Okay, so that might be a typo one.
Okay, I
Typo?
just want to be clear.
Okay, so 85 is what we requested.
So we'll make a note of
Yeah,
that.
so if we could go with the 85 feet, we'd like to.
Okay, I can address that with staff.
Okay, thank
During
you.
their presentation too, thank you.
The current use is vacant agricultural, and it has an existing agricultural exemption on the property. It's located in the industrial development land use. We're in the Gateway Airport Planning Community, and the location and mix of uses are designed to allow this property to serve as an employment center for the San Carlos and Three Oaks residents, reducing commute times in the region. Again, this is where the property is located. You'll notice it's just north of project called Florida Gulf Coast Business Center. This is really almost an identical rezoning as far as conditions, types of uses, intensities as they relate to square footage. Similar issues, we have a wetland on the south end of the property that is bisected by the property line, and then this property also has an old mining lake on it to the north. Here's the location map of showing the surrounding uses, our project location. As mentioned, we got MPD to the north, to the south, to the west. We have an IPD, also 2 IPDs to the west of us as well. This is one of the last, if not the last, property to be rezoned in this area that we call the North Alico Commerce. The total area is about 650 acres, so this is down to one of the last ones of being developed. We are located on 4-lane arterial, 3 Oaks Parkway, and then we also have the 2-lane major collector road, Oriole Road, that comes in at a 90 degrees towards the top of the project. I would choose the pointer, but I'd be afraid I'd turn it off. Again, this is the land use map showing that we're in the industrial land use category. This is our master concept plan. Again, we're showing the wetland to the south to be preserved. That's already in a conservation easement, and the lake that's on the property is part of the overall master drainage system for this entire subdivision area, which is this entire 650 acres is part of one large water management system that has a series of canals that go east to west to vertical, I'd say vertical north-south lakes on the far west side of it. It's all part of that system, and again, this lake and this wetland are incorporated into that drainage system for that. So if you notice, it's actually bigger than we would typically for a project this size, and that's why, because it's an old mining, and that was incorporated into that permit. Again, the site's in the Gateway Airport Planning District within the industrial development and wetland future land use categories by LEED plan for the wetland area. The industrial development future land use categories is reserved mainly for industrial activities and selective land use mixtures. According to the LEED plan, appropriate land use mixtures include industrial, manufacturing, research, recreational use, and office complexes. Retail and recreational uses may not exceed 20% of the total acreage within the industrial future land use categories for each planning community. So it's not for the project, but for the overall planning community. There is wetlands located along the south property line that extend into the south parcel that we talked about, and all development in wetland must be consistent with Goal 124, but we are not impacting that wetland as part of this. Property falls mostly within the airport noise zone B. This overlay requires formal notification of all tenants and purchasers consistent with LDC section 341104B. And then the conditions included a staff report to that point. The property fronts on 3 Oaks Parkway, which is an arterial road. We have water and sewer services available to the site. All urban services are available to the site, and the area is planned and is being rezoned to develop with uses similar to this development project. Water and sewer lines, again, are within the vicinity of the property. They're already there. Development meets the threshold for development of county impact and is being reviewed as a mixed-use plan development. The area, due to its location and future land use designation, is appropriate for industrial and commercial uses as it fronts on an arterial road and is not adjacent to any residential developments. The rezoning request is for mixed-use development. We contain sufficient infrastructure for the industrial development. We're in close proximity to I-75. We obviously have frontage on I-75. The interchange is Alico to the south. Planning District, Planning Community's map and acreage allocation table depicts proposed distribution, extent, and location of generalized land uses for the year 2045. Subject property uses Gateway Airport Planning District, and the LEED plan is allocated 1,216 acres of commercial, 2,134 acres of industrial within this planning district by year 24. Currently, there are 168 acres of commercial uses and 680 acres of industrial development. There are approximately 1,048 acres of additional land allocated commercial uses and 1,451 acres of additional land allocated industrial within the Lee County, this planning district. So get to our deviations. We have a number of deviations. Deviation 1A was something that staff was not supporting and asked us to withdraw that. We agreed with that. That was for, basically it was for an ornamental or secondary lake on the property, not so much for water management, so we figured we'd go ahead and withdraw that. If there is a need for it later on, we'll address it at time of DO through an administrative deviation. 1B is to 25-foot property line setback and or allow a 0-foot property line setback when the lake is combined with adjacent property. This is more of a cleanup to account for the fact that the lake, well, actually in this case, the wetland straddles the property, and to the north, the lake straddles the property as well. The existing lake slope, a ratio of 4-to-1. So the new conditions is that lakes have to be a 6-to-1, but since this is an existing lake, we're asking for deviation to leave it in its current configuration. And we're also asking for a deviation to not require fencing around the existing or proposed lakes. The fencing requirement, in the code, it actually says it's at the discretion of the director, but we ran into it before. We felt like we had to add it to the deviation, so that's why it's there. I'm not really sure it's technically a needed deviation, but we got burned on it once before. So landscape standards deviations. So we're asking for, well, because we have the 5-acre conservation easement area and the lake track, we're trying to use those, incorporate them into reducing our open space threshold. We had originally asked for a 20% open space for commercial and 10% for industrial. Through the process, the 20% went up to 25% for commercial, but we're still at 10% for industrial uses. And then as far as to permit native wetland trees to be substituted for 100% of the total number of herbaceous plants required. That's our deviation 2B. Street design, we're asking for a deviation to allow only street plantings on one side of the road and to allow 100% of the trees be palm trees and clustered on that side of the road. This, I don't know if it's a fairly new code anymore, but there's a code there where it requires plantings within the right-of-way on both sides of the roads. We've found that that's become problematic, especially when people are putting canopy trees so close in the right-of-way, it becomes visual problems. So we're asking for the deviation to do palm trees. I know there's been discussions, I don't know if they'll ever happen, about removing this condition from the land development code. So I guess I'd like to just clarify that if that condition in the land development code ever goes away, that we'd like to also take advantage of that and not have any street plantings. So I'm not sure where the county's at with that or if that's ever going to happen. And then internal roads, access ways to be constructed without cul-de-sacs. So typically what we'll do at time of DO, we may get a letter of no objection from the fire department to either do a hammerhead or a future stub out for a project. So that's where that deviation is coming into. Deviation for signs. So this is the deviation that staff is not supportive of. It's to permit one additional sign on the project's frontage. Oh, actually not this one, but for 3 Oaks Parkway, for a total of 2 ground-mounted signs on 3 Oaks Parkway, and to allow 2 signs on 3 Oaks Parkway with 200 square feet of per sign area per face. This is a deviation of an additional 100 square feet of sign area on 3 Oaks Parkway. 4C, so this is one. This is to permit one 300 square foot electronic sign for business along I-75. This deviation is consistent with the deviation approved for the Florida Gulf Coast Business Center. This is the one that staff is not supporting. And our argument for asking for this, as mentioned, there's a similar signage on the property to the south of us, so we're trying to mirror that same ability to do that. The code basically says that if you have frontage on 2 arterial roads, you can get 2 signs, but obviously we don't have access on arterial I-75. We're not allowed the signage, so we're asking for the deviation. We're deviating from the portion of the code that says if you don't have access on 2 arterial roads, you can't get access onto it. So that's the portion that we're deviating from. I think there's some concerns on staff's point that it's just simply not allowed, so we can't ask to deviate it. But we kind of want to narrow into the fact that the sign would be allowed if we had access on I-75, and obviously you can't, so that's where we're asking for the deviation from.
So is there any difference? I pulled the ADD that you referenced in the 48-hour letter, and that appeared to deviate from a different code section altogether. So what is the actual code that you're deviating from? Because the ADD went from 3153-2 and 2A2. This deviation that you're requesting is from 30, 153-1B21, or excuse me, B2I.
Yeah, and I believe that's the portion of the code during our review. I don't know if, Richard, you want to chime in a little bit on that. That's the portion of the code. I'm not really sure exactly why we didn't address both of those sections in the ADD. I think at that time, staff didn't ask us to. They only asked us to address that one portion of it, and maybe both parts of that section should have been addressed. But I don't know if you want to chime in a little bit.
Sure, be happy to. Good morning, Madam Hearing Examiner. For your record, Richard Aiken. So in looking at the ADD, and I reviewed it as well, it looks like, so if you look at 3153 subsection 2, it talks about non-residential subdivisions, and then if you look at 2A, it says a non-residential subdivision or a multiple occupancy complex of more than 5 establishments shall be permitted one ground-mounted identification sign along any street which provides access to the property as follows. It's a different provision. I think it is the same issue because if you look in subsection 1 of 3153, we're looking at 3153 1B2I. And if you look at B2, it says parallel street frontage. Uses with frontage on 2 streets which do not form a corner lot shall be allowed sign area credit for the second street as follows. And then both streets collector or better when both streets serve as a collector or better and public access is available from both streets. That seems to be the operative language that I think the county is looking at here to say that, well, we can't grant you a deviation to allow a sign here because you don't have access to I-75. So it's the same requirement exists in subsection 2 as it does in subsection 1, which is what we're looking at. Whether in that ADD there should have been a deviation from subsection 1 as well, I could Monday morning quarterback it, but I wasn't there, so I think the question that, and I would also point you to 3153 subsection 5E, which is at the end of the sign ordinance here, and if you look at down there, it says the variances and deviations, no variance or deviations from subsection 5A through D of this section may be granted, all right? And so we are not asking for a variance of that subsection, so the sign ordinance in and of itself does not on its face prohibit a deviation from the requirement that we are asking for a deviation from. Therefore, I would argue that the general standard for deviations therefore applies. We may be in a bit of a gray area here. The provision doesn't prohibit a sign in this location. It just talks about when you get credit. So if you look at it again, I'll read it. It says that uses with frontage on 2 streets which do not form a corner lot shall be allowed sign credit for the street as follows. We do have frontage on I-75, but then I says when both streets serve as collectors or better and public access is available, this is how you calculate the square footage. So it doesn't, I don't think, as I read it anyway, prohibit a sign in that location. It allows signs where there is frontage, and then just because we don't have the access, we're asking for a deviation from how you would calculate it because of the lack of access.
And that was my question, because the way I'm seeing it is subsection 1 specifically calls out that's the calculation of the permissible area. So there we're talking about sign size and how much square footage you're looking at, and I think you're looking at 300 square feet for this one. 2 seems to be more locational in my reading, and so then 2A talks about the identification sign being permitted along any street which provides access. So I'm assuming that that's the language, and obviously I'll hear from staff when they present, but I'm assuming that's the language that they're concerned about or pointing to, and then 1-2 then gets into the sign, the size. So they're all connected, but that was my question, I guess, is the ADD deviated from the location, whereas this deviation is talking about the size, but I don't know if you even need a size deviation because it allows 300 square feet if it's permitted at all. So it's just kind of a chicken and egg circular argument that we're getting in, but I want to be sure that we're clear at least on what you're asking to deviate from. And then if you can provide any background about the ADD that happened in 2020 and if that conversation occurred at that time and if maybe it was just an oversight or if that wasn't even an issue that was being raised, whatever you can do to illuminate would be appreciated.
Yeah, I'll just state that, I did look through the file from the ADD and I didn't see any specific discussion about the location and the access issue when I reviewed it. It looked like staff focused on the height of the sign was also part of the deviation request, so that seemed to be what they were focusing on, and that sign is there today. If you drive down I-75, I'm sure you've seen it. So I wasn't part of that. I just reviewed the file, so maybe Mr. Quattrone can add something else.
Yeah, and my recollection is there wasn't discussions about not being able to have it. It was more size driven at that time. So we kind of, that's how we submitted that application.
So this particular deviation, that what you're requesting here is not the size, it is the location.
I believe that it is probably a little bit of both. So I think that it is in order to get the size, the calculation is based upon access. So we're asking for a deviation from the provision that calculates the size. But I also believe that subsection 2, as we've discussed, comes into play as well, and probably for clarity's sake would need to be mentioned in the deviation.
Okay, I just want to be sure we cover the bases. And 4A and B deviate from the section that the ADD deviated from to some extent. It's still a different subsection, so there's a lot of, again, pieces of this, but I want to be sure we cover all the bases so that once we get to a resolution, there aren't remaining questions after the fact.
Yes.
So, okay, thank you, and I'll address it with staff when we
Thank
get
you.
to their presentation. Thank you.
So then deviation number 6, permit proposed local roadway shown on master concept plan, required interconnection. Let's get that real fast. Yes, that's just a, for lots 2, 3, 5, 6, 7, 9, and 10. And if you want, I could flip back to the to the master concept plan. That might help explain it a little bit better. So that deviation, what we're trying to do is, the LDC is now requiring and pushing for a lot of interconnectivity of parking lots. Our thoughts were when the intent of our north-south road, or actually even all of our internal roads, is to allow those local private internal roads to allow us the interconnectivity for the subdivisions, and without having to make every single parking lot interconnect, which has become problematic during time of development order. And again, staff appears to be supportive of that one as well.
Can I just clarify, it's deviation 5 listed on the proposed conditions. I don't have a deviation 6, but the master concept plan is keyed to deviation 6. Is there a 6th deviation?
Is that a- Well, yeah, I think that's just a typo on our part. That should have been deviation 5.
5?
Yes.
Okay, so we'll need to update the master concept plan then too, just to get that straight. Okay.
Okay. So basically, in conclusion, sufficient evidence has been provided within this application to demonstrate that this rezoning is in compliance with the LEED plan. In addition, sufficient evidence has been provided with this application to demonstrate that this rezoning is in compliance with the Land Development Code and all other applicable rules and regulations, including compliance with all zoning provisions and supplemental regulations. The request is compatible with existing or planned uses in the surrounding area. The project with provided access is sufficient to support the proposed development intensities. The expected impacts on transportation facilities will be addressed by existing county regulations and conditions at time of development order. The request will not adversely affect any environmentally critical areas or natural resources. Urban services are available to the site. The request is consistent with densities, intensities, and general uses as set forth in the LEED plan. The proposed conditions are sufficient safeguards to the public interest and are reasonably related to the impacts of the public's interest expected from the proposed development. The deviations enhance the achievement of the objectives of the planned development and preserve and promote general intent of the code. The request will not cause any damage, hazard, nuisance, or other detriment to persons or property, and the request will meet or exceed all performance and location standards. So that, unless you have any other question, that concludes my presentation.
Just a couple of quick ones. The The narrative, I think it was in your narrative and the staff report both talk about there being some conversion matrix if you're going to do hotel rooms, because otherwise it's a straight 1-for-1 of commercial and industrial square footages. Is there some matrix somewhere that lays that out that you'll have to do at the time of DO? Because right now the condition in condition 1 just permits the full range of everything, including the full square footage plus the hotel rooms.
Yes, that should be the intent of it. Yeah, I think we're trying to get away from matrices, so it'd just be the full square footage with the hotel rooms.
But there's some conversion you'll have to do at the time of DO to be sure you're staying under the trip count, because the TIS didn't seem to contemplate the hotel rooms. They just looked at the square footage for like a commercial shopping center or warehousing use for industrial.
Okay. Yeah, time of development, I guess we'll have to analyze that, look at that conversion. Hotels don't typically generate a significant amount of traffic, especially as compared to medical uses and so on, so I don't see that as being an issue, but I guess we'll have to address that at time of DO.
Okay. And then to your knowledge, I know there's no one for the environmental here, but the environmental staff report said when they did their site inspection, they did see some gopher tortoise burrows and some other evidence of species, but the subsequent protected species survey that they asked you guys to update said that there was no evidence of any species because there had been rain. So to your knowledge, as of right now, are there any species on the site that you're
Not that I'm aware of. I do know once we go in for development order, we'll have to update that. And gopher tortoises seem to move around more so than I ever thought. So again, we'll have to evaluate at time of development order for each parcel.
Okay. But nothing has been submitted yet for a DO?
Not that I'm aware of. Oh yeah, no development orders have been submitted.
Thank you. That was all the questions I had for right now. Thank you.
Okay, thank you.
Ready for staff whenever you're ready, Sharon.
Oh.
Good morning.
Good morning. Sharon Badamchian from the county zoning. My resume is on file. I was recognized as expert in zoning and land use. In the past, I would like to be recognized as such at this time.
Yes, thank you.
Member Examiner, this project was duly advertised, and I have a copy of the affidavit for advertising.
Thank you. That'll be Staff Exhibit 2. Staff Exhibit 1 is the staff report.
Well, as Mr. Quatron mentioned, they are requesting to rezone 58, almost 59 acres from agricultural to mixed-use plan development to allow for 705,000 square feet of retail and industrial uses and a hotel, 200-room hotel. Their TIS did not really mention hotel, so that's why we have a condition that if they want a hotel, basically we have to reduce the square footage of the industrial or commercial. And basically, transportation handbook, they have some matrix, how much a hotel room, how many trips a hotel room generates versus how many trips a square foot of commercial. So we are going to use the latest version of that book to determine the number of square footage of commercial they have to reduce in order to build a hotel.
Where is that condition, though? That's what I was looking for, because condition 1 just says they're allowed 705,000 square feet office, commercial, retail, industrial, and 200 hotel rooms, and I didn't see any subsequent condition. It's talked about and mentioned in the staff report that there would be that intention, but I didn't see that memorialized.
Commercial, the condition might have been left out.
That was the nature of my concern and my question, is generally you see that condition.
Yes.
It's not here, and so right now, under condition 1, they can do the full array of 705,000 square feet plus 200 hotel rooms, and that's not what was evaluated, so I'm just
No,
curious.
that was not how it was evaluated. You are absolutely right. I apologize, that condition was left out. We take care of it. And
I'm guessing it was intended, you go from 5 to 7, so maybe it was 6, and maybe it just got dropped off somewhere along the way.
it's possible that it was somehow eliminated during. Yeah, probably it was condition number 6. Okay. And the future land use designation of the industrial development, we had several of this type of rezoning in the area. I think this is the last agricultural parcel that's left. And they are requesting basically uses that were approved for in the area for the other developments that we rezoned in the past. They are requesting 12 deviation with that, and staff recommending withdrawal of 1, which they agreed. And the main issue, I believe, is the sign along I-75. We had some issues with that, and I contacted Mr. Quattrone's office, and we discussed it, and we got an email saying, this is the section we want a deviation from. And I read that several times, and that thing did not really allow signs along I-75. And we have a section that talks about signs at the ramp, properties closer to the ramp, but this one is nowhere close to any ramps. So that's the reason staff recommended denial of that. With that said, what other issues they were? I think that's about it.
Well, did you review the ADD after they cited that to see that? And see
Well, I did not receive the 48-hour notice. It wasn't sent to me. But I have no reason to doubt that it was approved. But the way they asked the deviation, that did not allow a sign along I-75. And that's the reason staff recommended denial of that. I mean, if they can come up with other section of the code that would allow, then we have to look at it to see if staff can support or not. But as requested, staff is not in favor of approving that deviation.
even knowing that there's the one immediately south of it. I'm just trying to get to what the concern, because generally when signs, we're concerned about visibility issues, right? Safety for the traveling public. But in this case, they're asking for, it sounds like exactly what the property to the south has. And if it was allowed as a deviation in a prior case, just the fact that the code doesn't allow it, that's why they're asking for the deviation, right? Like I'm just trying to get to what the justification is so I can evaluate both sides.
Well, all I can say is the section of the code they cited, and after our conversation, they emailed to us, did not allow them to have a sign there. And if they want to ask deviation from a different section of the code, well, we have to evaluate that. I mean, I agree that if it's approved the property to the south, the exact same deviation, we cannot really deny this, but we have to look at it.
So it's a code section citation issue.
Basically, code section issues, and even after our discussion with them, they said this is the section of the code we want a deviation from. With that said, they are in full compliance with all the requirements of the LEAP plan and the land development code. Staff recommends the approval of this.
Did you have any objection to 85 feet if that was, it looks like that is what they requested in the application that I have in my material.
No, it could have been a typo.
Okay, so 85, staff does not have any concern about.
I don't believe so.
Thank you. I will need to leave the record open for a few things, but one of the things I noticed was attachment K3 included a different case. It's shown as, let me see what it is. It's shown as Z21009, and I think you meant to approve Z22009. Z21 is on the opposite side of 75, so I just, for the record, I can't substitute that in, so since I'm leaving the record open anyway, if you can just
Okay.
replace that, so we've got a complete record going forward, since this will go to the board. Okay, and then we can just discuss this. It sounds like the sign issue is really all we've got, so
Yeah, I
if
mean,
you have any other questions?
we can leave the records open and they can give us the correct section of the land development code that they want a deviation from, and we can look at it, and probably we can have a joint submittal for that.
Okay, so staff doesn't have a substantive objection to the sign being there, you just have a concern about which citation they're using?
Well, the citation they're asking deviation from doesn't allow the deviation.
Give me 1 second, and let me make my notes here. If you want to sit down, I don't want to make you stand there the whole time. Yes, please, for the applicant.
Thank you, Madam Hearing Examiner. For your record, Richard Aiken again. So I just wanted to go back, trying to find something that shows the site plan. Here we go. Okay, so the request was for a deviation from 3153 subsection 1B2I. And I believe that the reason for the requested deviation from that is because that's how you calculate sign area, all right? And because we don't have access to I-75, we're asking for a deviation to calculate the sign size based upon that subsection, right? The discussion that we seem to be having, and the issue that I believe staff has, if I understand correctly, is not the size, but the location. And so looking at subsection 2, and that was what the ADD allowed an administrative deviation from. It talks about sign location. And 3153-2A talks about an identification sign. And it says a non-residential subdivision or a multiple occupancy complex of more than 5 establishments shall be permitted one ground-mounted identification sign along any street which provides access to the property as follows. And then it goes through that, right? So I think the confusion on our end here, after I've spoken to Mr. Quattrone a little bit, is that, so the sign in question is right here at the end of this access road. And so not clear, well, I understand that it is also adjacent to I-75 and there's no access from I-75, but there is access to the property along this road. And so the question being, do we really need a deviation from subsection 2 given the location issue? And we can have that discussion further if we need to, but I believe that the understanding at that time was that we didn't need a deviation there because of this, what I think would ultimately be a local access road right here, which the sign is adjacent to and along. In the case of the ADD, the sign was, and Mr. Quattrone, can you tell me approximately where the sign is down here to the south? It's further this way, isn't it?
Obviously much further to south.
It's much further south. But I don't believe that it's adjacent to an access road, which may have been why they requested the deviation from subsection 2 in that particular circumstance. And it may be that they also should have asked for one from subsection 1 when they calculated the sign size, but again, I don't know how they got there. So again, I come back to just from a reading of the code, and it perhaps could be a little clearer, but at the end of the day, I'm not sure that we need a deviation from subsection 2, but in order to calculate the size, from subsection 1. We're happy to discuss it further with staff if we need. My understanding is that staff's position is the sign's not allowed in that location, and so it's sort of a question of whether we can deviate from it or whether we cannot.
Right, and that was what I was trying to get to, and it sounds like they're amenable to the sign. It's just a matter of the route that you have to take to get there in the document. So what I want to do, I think if you revisit deviation for A and B and C, because in A and B, you are deviating from 153 to A for other signs, and so maybe you can add this sign into that location just in an abundance of caution. And then it seems like for C, my guessing is, based on what you just said, the intention was to calculate the square footage, and that required both streets to be a collector or better, which the internal street is not going to be. So maybe it's just, again, getting that worked out. So we're leaving the record open anyway. Let's just leave that open so you guys can have that discussion. It sounds like there's agreement on both sides, of just a matter of how you're going to get there might require a little bit of housekeeping for us to do that. So let me do that. I want to go through the items that we need to address, though, in the written submissions. And they're all housekeeping, except for this issue about the sign, but just so we've got all of our ducks in a row. So I need to get an updated master concept plan that removes reference to deviation 6, since there is not one. I'd like to replace attachment K3 with the correct zoning resolution, so we've got that. We need to add the condition 6 back in to the list of conditions, if that's the intention, which again, it sounds like both parties agree to. We just need to spell that out for the hotel conversion. I don't need the matrix, I just need something that discusses that there would be some, thank you. Okay, and then with respect to deviation 4, we need to get some clarity on that, if we could. And just as an abundance, you referenced the ADD, but that wasn't provided in the 48-hour letter, so if you can just provide that as well, so I can incorporate that into the package that's gonna go to the board, so it's all in a nice bow, that would be fantastic.
And may I ask, do you want, for the ADD, do you just want the resolution?
Yes, just the 2 pages, not, I couldn't, if you have it, that would be perfect. I actually couldn't print the whole thing because I only printed 2 pages, and then my printer got very angry with me because I think the paper size changed to 11 by 17 or something larger. Thank you. Okay, so this will be applicant exhibit 2. A, again, was the 48-hour, 1 was the presentation, 2 will be the ADD 2020-00139. Okay, so how much time would you guys like to work through that? I can tell you I've got a number of cases in front of this one, so it's going to be a little bit of time before I get to it, so you're not holding me up if you need some time to work it through.
I'd say only probably a couple weeks, I would think at the most.
Okay. So let's see here if I can get my mouse to work. So let's say 2 weeks would be Friday, November 8th by end of business. And of course, if you need more time, you can always request that in writing. Okay, that was the extent of everything that I had. Did anybody have anything further? Mr. Freeman? Good morning.
Good morning. For the record, I'm Alan Freeman, representing the applicant. First of all, I'd like to thank everybody for showing up, and I'd say this early because it's early for me, but I guess it's not early for everybody else. I appreciate the attention to the file and the request. I'd like to just go over a couple of things that I heard as clarifications. There's no issue. So the height was requested, and I think the 85 feet was a clarification there. Again, part of the situation is this property has a preserve and a large lake, so we're trying to achieve the proper mix and density with some height. We are trying to do more of an office park here, similar to Florida Gulf Coast Business Center to the south, and we think that'll be quite successful here. The first thing I heard was, and maybe I missed it, but I didn't hear Mr. Quattrone and Mr. Aiken say that they were experts. So I would like to qualify them as experts, even if they don't. So just mentioning that. The open space issue is not a reduction for the subdivision, it's a reduction for the lots because of the large open space in those 2 areas. I just wanted to clarify that. The sign issue is one where we've got people, a lot of them coming to the property from I-75, and therefore we're just trying to let people know what's there so that they don't drive by it. And there are a couple of other issues with I-75. There were collector-distributor lanes, so it makes it even a little more confusing. I'll let the experts figure that one out with the presentation. As far as the hotel, yes, it was anticipated that a calculation would be done of traffic to determine how much traffic the hotel would require and then do some reduction based on that. And I think, you know, there's an 11th edition, I think, is the current edition, but usually whatever that edition is, by the time we get to it, it's changed to the 12th or the 13th. And we would expect to use that rather than a conversion table because that's what DOT has typically told us they would prefer rather than some fixed table. I think the other one was our little burrowing owls. I don't think they would go for tortoises, but I could be wrong. In any event, there aren't any that have been identified at the moment. And again, we do understand that at development order, we would have to study that again, so we expect to do that. I think with that, ordinarily I like to tell a couple of jokes and make people feel like I'm a nice guy, but I'm out of material here. So I think that's the case. I think it's a good use in that area, and that whole Three Oaks Commerce Center was designed to provide employment closer to where the residential is in that area and hopefully cut down on trips, but also allow people to have a good employment center right in that location near the airport, near the university, and near a bunch of residential communities like San Carlos Park, Three Oaks, and the communities to the east. So we appreciate your attention. If there are any questions, I'll be happy to answer them, and if you don't have any, that's even preferred. Thank you very much.
Thank you. Okay, so with that, we will conclude for today. I thank everybody for coming. Please stay well, stay safe. And of course, this recommendation will go out before it goes to the board, and you'll be receiving notice of that date once it's scheduled. Thank you.
Thank you.
Thank you.